Hi, good morning everyone. How are you all? Hope you are all very good. And this is Anuj. And today I'm here with you all to have a discussion on public announcement. Basically, we will discussing here about the public announcement and when we have to just go for issuance of the public announcement. We will be discussing entire things relating to the public announcement, and I will be also presenting here the format of public announcement and how we need to fill the details in public announcement. So let's we go. So here, here we will have to check about the public announcement. Basically, Section 15 of Insolvency and Bankruptcy Code, and which deals with the public announcement. So we will have to just check out the Section 15 of the Insolvency and Bankruptcy Codes. Basically, Section 15 deals with the public announcement, and it clearly states that Section 15, subsection 1, that the public announcement of the corporate insolvency resolution process under order referred in section 13 shall contain the following information. बेसिकली मैं आपको ये बताऊं कि पब्लिक अनाउंसमेंट के लिए सेक्शन 13 में की जो ऑर्डर होती है ना, बेसिकली सेक्शन 13 के अंदर एनसीएलटी ऑर्डर पास करती है relating to the commencement of corporate insolvency resolution process of the corporate debtor, and उसी ऑर्डर के अंदर पब्लिक अनाउंसमेंट करने के लिए एनसीएलटी मेंशन कर देती है कि यू रेजोल्यूशन प्रोफेशनल इज रिक्वायर्ड टू मेक द पब्लिक अनाउंसमेंट. So, public announcement basically is required to be made within 3 days from the date of commencement of corporate insolvency resolution process of the corporate debtor. And what are the details which we need to prescribe under public announcement that are as follows. First of all, Section 15, subsection Section 1, Clause A, it states that name and address of the corporate debtor under the corporate insolvency resolution process. Name of the authority. Here, basically, in subclause A, you need to mention the name of the corporate debtor and SIN number of the corporate debtor and address of the corporate debtor, registered address and corporate address. Both the address is required to be prescribed in the public announcement, and you have to just also mention the SIN number of the corporate debtor. So basically, these details are details are required to be mentioned in uh, subclause A. And in subclause B, basically, you have to just mention the authority with which the corporate debtor is incorporated or registered. So basically, we have to just mention if a company is based in Delhi, then we have to mention that the company is registered with Arush Delhi. And if company is registered in Mumbai, so we will have to mention that Arushi Mumbai. So basically, we have to just mention the jurisdiction of the Arushi under which the company is falling. Next, in subclause C, the last date of the submission of the claims. Basically, the date of submission of the claim is within 14 days from the date of issuance of the public announcement. Let's say if public announcement is made on today, that is on 24th of September. So from this date, we will have to count next 14 days, and within 14 days, claim is to be submitted before the interim resolution professionals. And in subclause D, the details of interim resolution professional who shall be vested with the management of affairs of the corporate debtor and responsible for receiving the claims. So in clause D, we will have to also prescribe the details of interim resolution professionals, name of the interim resolution professionals, IBBI registration number of the interim resolution professionals, and the address, email address. So all these details are required to be prescribed in clause D. And in clause D, penalties for the false or misleading claims. If any creditors are furnishing any misleading or false informations before the IRP relating to the claims, then there will be the consequences of that has to be prescribed as well in clause A, the date on which the corporate insolvency resolution process close. So basically, this is the date 188 days from the date of the commencement of corporate insolvency resolution process. Let's say let's understand with this example. If the corporate insolvency resolution process is starting today, so we will have to count 180 days from today, and next 180 at the end of the 188th day, the corporate insolvency resolution process will close, and here which shall be the 180 day from the admission of the application under section 7, 9, or section 10, as the case may be. So the public announcement under this regulation shall be made in such a manner as may be specified. So, dear all, we have just looked section 15 relating to the public announcement. What section 15 is required to be studied with the regulation of the corporate insolvency resolution process. So, we will have to check out the regulations relating to the public announcement. So, let's go to the regulation of the public announcement. So, here I will be presenting you this regulation. So, this is the corporate insolvency resolution process regulations relating to corporate insolvency, relating to the CIRP of the corporate debtor. And here we will have to just check out the regulation 6 of the corporate insolvency resolution process, and this is the regulation relating to the public announcement here. Public announcement, basically, there are the only three regulations relating to the sub regulations under regulation 6 of the CRP regulations. So basically, it's, sub regulation 1, Regulation 6 of Regulation 1 states that the insolvency professional shall make a public announcement immediately on his appointment as interim resolution professional. Here is the date is immediately, at the earliest, or can be made. But immediately means not later than the 3 days of appointment. You can just do at the earliest. But not later than the 3 days. If you are issuing the public announcement after 3 days of your appointment as the interim resolution professionals, then it will be treated that the public announcement is not made within a time, and this is the default. Somehow we can say. Next. Regulation 6, Sub-Regulation 2. The public announcement referred to in Sub-Regulation 1 shall be in Form A of the Schedule 1. Basically, there is a specified format of a public announcement. We need to fill the details in that format only. And once after filling the details, that public announcement is required to be signed and dated by the interim resolution professionals. And here, let's see. And Regulation 6, Sub-Regulations 2, Clause B, Subclause 1, it will be published in English and one regional language newspaper with wide circulations at the location of the registered office and the principal office, if any, of the corporate data. Basically, we will have to just one English, one regional language having wide circulations where the company is having its registered office and principal office, if any, of the corporate data, and any other locations where the opinion of the interim resolution professionals. The corporate data conducts material business operations. So basically, this is the prescribed under regulations that it should be in English newspaper and one should be in the regional language newspaper, and where the company is having its registered office and principal office. Registered office and principal office. If company is having only one registered office, it will be at the registered office, and if companies are having a principal office at the different locations, so we will have to also check out the regional languages which is being followed at the area where the company is having its corporate office. So we will have to also publish the public announcement to that in that areas in the regional language of the. And if the company IRP is having view that it should be published in some other locations where the business operation of the company is situated, so in that area it can also be published. So this is here it's depend on the opinion of the interim resolution professionals. And here in clause second, we will have to just check out the on the website, if any of the corporate data, once you have prepared the public announcement and you have just published in the newspaper, then you have to also host that public announcement on the website of the corporate insolvency, corporate data. Sorry, it has to be published on the website of the corporate data. If any, it's not mandatory. If the company is having website, then you need to publish there. And if company is not having, you can't do anything. And you are just designing the website of the city for the certain purposes under IBC, then you can also do there. And next, you have to just publish on the website if any designated by the board. So basically, on the website of the board, you need to also publish there. And clause VA basically states that where the claims forms can be downloaded or obtained from. Basically, you need to just provide a link in the public format of the public announcement, from where the creditors can just simply click on that links, and that link will direct to them to download the download option of the public announcement, download link of the claim form download. So basically, this is the requirement. Earlier, it was not in the public announcement, but certainly after the amendment, and it was brought on because this was creating difficulties for the creditors, because creditors are not having the knowledge about the from IBI website, or else relating to the IBC. So simply, the purpose is that to provide very hassle-free services to them relating to the claims. So basically, on the link will direct them to just download the claim form. And next, uh, clause double B offer choice of the three insolvency professionals identified under regulations for a to act as the authorized representative of the creditors in its classes. Basically, this is only for the some sort of the companies, real estate companies, or where there is the class of the creditors in the companies. Then the it will be also available and options to the class of creditors, to identify one of the professionals out of three to act as their authorized representative. So this is not applicable for all companies, but yes, certainly yes, for those companies where there is the class of the creditors. And just I want to have a quick uh, uh, discussion on this relating to the class of creditors. Basically, class of creditors can be of the home buyers and depositors and debenture holders. So these can be the class of the creditors. And if the company is having any sort of these class, then the option relating to identifying one of the professional out of three IP as the authorized representative will be given to the creditors. And in C, basically provide the last date for submission of the proof of the claims, which shall be the 14th, which shall be the 14 days from the date of the appointment of interim resolution professional. As we have had discussion relating to that claim shall be filed before the uh, IRP within 14 days from the date of the submission of claims. Here, I want to add one thing, that although the time prescribed under public announcement is 14 days, but claims can be even filed till the issuance of the RFRP of the corporate data. Basically, I don't know, whether you know about the RFRP or not, but we will be having discussion on RFRP as well in some other videos. So basically, the latest amendment made it very clear that the claim can be filed before the RP till the latest by the issuance of the RFRP. So this is the new amendment, and basically this amendment was recently brought on 18th of September 2023. So this is the new amendment. Earlier it was 90 day from the commencement of corporate insolvency resolution process regulations, but now it has been amended by the IBPI. Next, in sub-regulation 3, the applicant shall bear the expenses of the public announcement, which may be reimbursed by the committee to the extent it ratifies them. Basically, it states that whatever expenses is incurred relating to the public announcement has to be ratified by the COC members, and once ratified, the Applicant means the person who file applications for commencement of corporate insolvency regulation process will be getting the amount relating to the public announcement. So this is the entire regulation 6, which deals with the public announcement, and I'm pretty much confident that you have shown the ideas about the public announcement. So we have covered section 15, and we have also covered regulation 6 of IBBI corporate insolvency resolution process regulation. So आप जब भी कभी पढ़ रहे होंगे तो section 15 along with regulation 6 of IBBI corporate insolvency resolution process regulations को देखें, and along with these regulations you have to just also refer schedule 1, and in schedule 1 you will be getting the format of the public announcement, and as I have discussed earlier that I will be presenting you format of the public announcement, and so let's see the format as well, so we can have the little ideas about that as well. So here we go, and this is the regulations, so we can just check out in these regulations. At the end of this regulation we will be getting schedule 1, and public announcement as well. So let's see what the what the public announcement looks like. So yeah, this is the schedule. This is the schedule, and no, actually, this is the act. We will have to check in regulations. Yes. So this is the format of the public announcement. Basically, you have as specified Schedule 1, Form A, and public announcement. Under Regulation 6, we have it has been mentioned under Regulation 6, public announcement has to be made, and the Insolvency and Bankruptcy Board of resolution process of the corporate person regulation 2016 you have to just mention in this, and for the attention of the creditors of, here we need to just mention the name of the corporator, the company who is under CIRP, and basically name of the corporator. You have to just take the name from the website of MCA, and just you can mention this, and date of incorporation of the corporate data. You can check out this date from the Minister of Corporate Affairs website, and authority under which CD is registered. So basically you have to just check out with what are the jurisdiction of the RC, and you can just find out these details on the website of the MCA. Corporate identity number, in case of the company you need to prescribe SIN, you will be getting this detail on the website of the MCA, and if company is LLP, then you need to mention LLP identification number on their next insolvency commencement date in respect of the CD, whatever the date of the insolvency commencement date that is to be prescribed. Estimated date of closure 188 day is required to be made in section 8 in para serial number 8, name and registration number of insolvency professional acting as IRP. The need to prescribed here, and next address and email of the IRP as registered on the website to be prescribed here. Address and email to be used for the correspondence with the IRP need to be prescribed separately. Last date for submission of the claims need to be prescribed here, and class of creditors, if any, under clause B or on clause B of subsection 6A of section 21, ascertained by the interim resolution professional is to be prescribed. Their name of the insolvency professional identified to act the authorized representative of creditor in class need to be prescribed here, and relevant forms and details of authorized representatives are available, need to be prescribed here. And this is the notices here by giving that the national company or tribunals has ordered the commencement of the corporate insolvency resolution process, name of the corporator or insolvency commencement date, the date of acceptance of applications for initiation of the CIRP need to be prescribed, and the creditors of the are hereby called upon to submit their claim with proof on or before mentioned the 14th day of issuance of the public announcement to the interim regulation professional. At this mention against number 10, and the financial creditors shall submit their claims with proof electronic means only. All other creditors may submit the claims with the proof in person or post by electronic means. A financial creditors belonging to the class as listed against entry number 212 shall indicate its choice of authorized representative from amongst of the three insolvency professional listed against an entry 13 in 13. The details of the three insolvency professionals is required to be prescribed, and representative of the class of creditors in Form C, and submission of the false or misleading claims shall attract penalties. And here, name of the IRP and date and place. So, dear all, this is the basically formats which Schedule 1 contains relating to the public announcement, and this is very simple format. Nothing is technical in this. But yes, when you are preparing this at a first time, you will be getting some difficulties while preparing this public announcement. So I have I thought that we can have I can say share my experience, as I can tell you that till now I have handled more than 60 assignments in overall 5 years of working in IBC, as I'm working since 2017 in insolvency and bankruptcy courts. So I have started initiatives to just prepare a small videos of 10 and 20 minutes, and I can just share the practical experience relating to the various aspects in IBC. So this is the our initiatives. So guys, I'm not too much technical about the recording of the videos and editing of the videos. So there is a chance that you will be not getting good sounds and images. But yes, I can pretty much show that the content I will be sharing with you, that will be fabulous. You will be getting good informations, and please, if you find this video important and relevant, please don't forget to like and share. Thank you. Bye.